Let's talk who has standing to initiate family law proceedings seeking parenting orders here in Australia. Section 65C of our Family Law Act 1975 sets out who may apply for a parenting order. And it includes A, either or both of the child's parents, or B, the child themselves, or B.A, a grandparent of the child, or C, any other person concerned with the care, welfare, or development of the child. C is quite broad. As a result of Section 65CB, a child may commence proceedings in relation to their own care. Applications by a child themselves is quite rare in Australia, but there have been examples. For example, the 2010 case of Kendall and Kayat involved a 17-year-old girl applying to the court seeking an injunction against her mother and her stepfather and her own father, who sought to relocate her to Lebanon to get married against her wishes, and she was successful in that application. In 2010, the legislature enacted Section 65CBA to remove any doubt that grandparents had standing in the courts to seek parenting orders regarding their grandchildren. They most certainly have standing. Although the courts have a legislative duty to favour the rights of the parents, the courts may make orders in favour of grandparents. The 2008 case of Carlson and Bowden goes into detail regarding grandparent standing, and I'll pop the citation down below. That case shows that a grandparent is a legitimate first option for primary care when the parents prove incapable of meeting a child's care, welfare, and development. It's often seen as unclear who meets the threshold as an other person concerned with the care, welfare, or development of the child. The courts consider each application brought under Section 65CC on a case-by-case basis. The broad Section 65CC can be really important to cases involving homosexual de facto couples. In the case of J&M Residence Application 2008, twins were born to a mother through contraceptive assistance. The mother's partner subsequently applied for orders giving them joint parental responsibility, and the applicant had standing under Section 65CC in that case. There has been contradictory opinions of the use of Section 65CC through the courts. For example, in the 2002 case of R&M, after a father's passing, a neighbour who had often cared for the child during his father's illness was denied standing by the courts, stating that she had not met the threshold test under Section 65CC. The threshold test was set out by Justice Burr in the case of Cam vs. MJR in 1998. The threshold test requires that a person must have an interest in or concern about the child, but the circumstances of the child then had to be taken into account after the test had been met. What do you think about the range of people who have standing to seek parenting orders here in Australia? Let me know in the comment section down below. This video contains legal information, but not legal advice. I'm a divorce and family lawyer practicing in New South Wales, Australia. Follow me for more law talk and videos on cooking.